Issue that we're dealing with, Garza v. Idaho, the Supreme Court of the United States coming up this round. It's already been argued in oral arguments. I'm representing the respondent, state of Idaho, in my class Appellate Advocacy. I've already done oral arguments, and I'm working on my completed brief in support of the respondent, state of Idaho. So the issue presented is whether a criminal defendant is entitled to a presumption of prejudice under the ineffective assistance of counsel test, presuming prejudice, meaning that the criminal defendant doesn't need to affirmatively prove that there would have been prejudice, meaning that the proceedings would have possibly turned out differently. So there's two prongs in the Strickland test, which was established in 1984 under the Supreme Court case Strickland v. Washington, and the Supreme Court announced in that decision that there's two prongs that have to be met for any criminal defendant asserting an ineffective assistance of counsel claim to be entitled to an ineffective assistance of counsel claim, meaning that their proceedings were basically tainted by counsel's performance. So the first one is deficient performance. You need to affirmatively prove that counsel's performance was deficient, meaning that it's a reasonableness standard. Means that it fell below an objective standard of reasonableness that we treat when regarding counsel's actions in representing criminal defendants in the justice system. And very important, at least in my, for my part, is that there's a strong presumption of counsel's competent performance. And so, on the other end, the criminal defendant, Garza in this case, is asking the court to adopt what's called a presumption of prejudice in favor of him. And what that means is that he wouldn't have to prove, he doesn't have the burden of proof of proving that his counsel, in this case, had deficient performance, and then also it was like so objectively unreasonable that he shouldn't have to prove that he shouldn't have to prove that it was prejudicial, meaning that there was a probability that the proceedings would have been different. In our case, Garza, who is the criminal defendant, assented to a plea bargain, which 95% of criminal defendants do in our criminal justice system, and that plea bargain had a waiver of appellate rights. And so what happened in this case was that, of course, he signed a plea bargain, got 5 years in prison when he could have been subjected to a lifetime in prison under the charges that he was brought under. And then what did he do after he assented to this plea bargain? Of course, he wants to appeal the decision, even though he waived appellate rights. And so my argument is going to be heavily focusing on the deficient performance prong of this. And essentially what I'm laying out or proving is that counsel's performance in this context was not deficient because he was acting with this very recognized by the Supreme Court's presumption of counsel's competent performance, and that basically his professional choice to not file a notice of appeal when the criminal defendant asked for a notice of appeal was part of his strategy, and that it wasn't just a ministerial thing, it wasn't just pushing a paper. That paper would have meant that he breached a plea agreement, and that prosecution would then not be bound to the plea agreement either. And so he would be breaching his plea agreement. Prosecution would have free range to go ahead and try to get him life imprisonment. And so I am arguing that counsel in this context was acting within his professionalism and competence and deference that the Supreme Court has recognized for 35 years at this point. And that's what I'm doing.